Somewhere in a filing cabinet in Cheyenne, Wyoming, there's a folder with your neighbor's name on it. Not literally, but structurally. It could be anyone's. Inside that folder is a company. It has a name, a registered address, and a filing date. What it doesn't have is an owner listed anywhere a member of the public could find. That company might be 5 years old. It might be 12. It might have been sitting on a shelf, dormant, aging, doing absolutely nothing, since before you were born. And when a family with real money needs to buy a $40 million apartment, or a stake in a private jet, or a controlling interest in a vineyard in Provence, that shelf company gets taken down, dusted off, and put to work. This isn't a conspiracy theory. It isn't a loophole some hedge fund manager found last Tuesday. It's a century-old piece of financial architecture, and it is completely legal in the overwhelming majority of cases. The people who use it aren't hiding from taxes. Most of the time, they're paying every dollar they owe. What they're hiding from is you, the public record, the journalist, the ex-spouse's lawyer, the kidnapper doing reconnaissance, the rival bidder at auction who'd raise the price if they knew who was really buying. This is the invisible fortress, and by the end of this video, you'll understand exactly how it's built, who built it, and why. As of this year, the walls are being tested harder than they have been in a generation. If you've ever wondered how the ultra-wealthy seem to vanish from public records the moment real money changes hands, subscribe now, because we're about to open the folder. What a shelf company actually is. Let's clear up the vocabulary first, because these terms get used interchangeably online. And that sloppiness is exactly what lets grifters oversell secret company courses to people who don't need them. A shell company is any company that has no independent operations of its own. No employees, no products, no revenue. It exists purely as a legal vessel to hold assets, sign contracts, or take title to property. A shell company can be brand new, formed yesterday. A shelf company, by contrast, is a shell company that has been deliberately aged. It was formed years ago and then set aside, put on the shelf, with no activity, so that when someone eventually buys it, they're not buying a fresh, one-day-old entity. They're buying corporate history, a filing date that predates the transaction it's about to be used for. Why does age matter? 3 reasons, and this is where most explainers stop too early. First, credibility with counterparties. A bank underwriting a large loan, a private seller of a $60 million estate, or an insurer writing a policy on a super yacht will often look more favorably on an entity with a multi-year filing history than one incorporated the week before closing. It signals, rightly or wrongly, durability. Second, jurisdictional waiting periods. Some countries and some contract types impose cooling-off periods or holding period requirements before an entity can participate in certain transactions, receive tax treatment, or bid on regulated assets. A pre-aged shelf company can already satisfy that clock. Third, and this is the one nobody markets openly, timeline obfuscation. If a family is planning a major acquisition, a media asset, a competitor's business, a controversial piece of real estate, and they don't want the market or the press connecting the dots between when they started planning this and when the deal closes, a shelf company breaks that link. The paper trail shows an entity that existed long before anyone started asking questions. Shelf companies aren't new. Corporate formation agents in Delaware and Nevada have sold aged shelf corporations since at least the 1980s, originally marketed to small business owners who wanted to appear more established than they were. The same instinct that makes people buy a 5-year-old company to bid on a government contract requiring 3 years in business. The ultra-wealthy didn't invent the shelf company. They just found a more expensive use for it. Here's the reframe this channel exists to make. None of this is hidden. It's just never taught. Every mechanism in this video is described in state statutes, bar association guidance, and estate planning textbooks. The information asymmetry isn't secrecy. It's access to advisors who bill $900 an hour and spent a career learning where the seams are. Drop a comment with the word layer if you already sense where this is going, because the shelf company is just the outermost brick. The real architecture is what gets stacked underneath it, and that's next. The layering architecture, how ownership disappears. A single anonymous LLC is a locked door. A layered structure is a hallway of locked doors, each one requiring a different key held by a different person, in a different country, under a different legal system. Here's how a family office actually builds it, mechanism by mechanism. Layer 1, the state-level privacy shield. In the United States, corporate formation is regulated at the state level, not the federal level, and states compete aggressively for incorporation revenue. Wyoming, Nevada, Delaware, and New Mexico have historically allowed LLCs to be formed without publicly listing the names of members or managers. What the public record shows instead is a registered agent, a person or company whose job is simply to receive legal mail on the LLC's behalf. The registered agent is not the owner. They're a mailbox with a law license. Layer 2, the nominee. For families wanting a second buffer, formation agents in these states offer nominee managers or nominee directors, a professional stand-in whose name appears on public filings instead of the real decision-makers. The nominee typically signs a private agreement, acknowledging they hold no actual authority. They act purely at the direction of the beneficial owner, who is named only in a confidential operating agreement that never touches a public database. This is the mechanism people mean when they say a company is anonymous. It isn't invisible to regulators or law enforcement with proper legal process, but it is invisible to a member of the public doing a Secretary of State search. Layer 3, the parent-subsidiary stack. A single anonymous LLC holding one asset is efficient, but exposed. If that entity is ever named in a lawsuit or a leak, it points to one asset. Family offices instead build stacks. A Wyoming LLC owns a Delaware LLC, which owns a New Mexico LLC, which holds the actual property or brokerage account. Each layer is a separate legal person under the law. Each layer can be dissolved, sold, or restructured independently. Piercing through all of them in litigation requires a court to justify piercing the corporate veil at every single level, a legal doctrine reserved for cases of fraud or improper commingling of assets, and one courts are historically reluctant to apply broadly. Layer 4, the offshore jurisdiction. For international families or domestic families wanting a layer outside U.S. court jurisdiction entirely, the stack often terminates in an offshore financial center, historically the British Virgin Islands, the Cayman Islands, or Nevis. These jurisdictions offer their own version of the same privacy protections, often stronger, along with favorable tax treatment on income that never touches U.S. soil. A BVI company sitting atop the domestic LLC stack means that even a U.S. court order compelling disclosure runs into a second sovereign legal system that may or may not recognize it. Layer 5, the trust. the final and most powerful layer isn't a company at all. It's a trust sitting above the entire stack, with the trust, not any individual, listed as the ultimate member. Trusts formed in favorable domestic jurisdictions, like South Dakota or Nevada, or offshore in Nevis, or the Cook Islands, can hold the equity of the top-level company. Now the beneficial owner isn't even a person on paper. It's a legal relationship between a settlor, a trustee, and beneficiaries, governed by trust law that in many of these jurisdictions doesn't require public registration at all. Stack all 5 layers, and you get what estate attorneys sometimes privately call a Russian doll structure, though inside the industry it's more often just called good practice. To trace true ownership from the outside, an investigator would need to identify the property, subpoena the domestic LLC, get a court order piercing to the next LLC, request international judicial assistance to reach the offshore entity, and then confront a trust structure that may have no public registration requirement whatsoever. Each step can take months. Each step can be legally contested. Most investigations, journalistic or even law enforcement, never make it past layer 2 or 3 unless there's a leak, which brings us to how the public actually finds out about any of this at all. This is the part of the video where half of you are tempted to close the tab because it feels like a lot don't. The next section is where all of this stops being theoretical, because we're going to look at what happened when 2 of these structures actually leaked to the entire world. Stay with me and hit like if the layering breakdown just reframed how you look at every anonymous LLC news story you've ever skimmed past. When the fortress leaked, the Panama Papers and Pandora Papers. For most of the 20th century, the public only knew this architecture existed in the abstract. Then, in 2016, and again in 2021, 2 of the largest data leaks in journalism history pulled back the curtain. The Panama Papers, published in 2016, came from a leak of roughly 11.5 million documents out of the Panamanian law firm Mossack Fonseca, a firm whose entire business model was forming and administering exactly the kind of shell and shelf companies described in this video for clients across the globe. The leak, analyzed by the International Consortium of Investigative Journalists, working with hundreds of reporters worldwide, revealed how politicians, business executives, and public figures across dozens of countries used offshore shell companies to hold real estate, art, yachts, and investment portfolios outside the reach of their home country's public records. 5 years later, the Pandora Papers leak in 2021, even larger, at nearly 12 million documents drawn from multiple offshore service providers rather than just one firm, showed that the practice hadn't slowed down after Panama Papers. If anything, it had diversified across more jurisdictions and more providers, precisely because families and their advisors learned to avoid concentrating risk in a single firm the way Mossack Fonseca's clients unknowingly had. What both leaks made clear, and what's important for a mechanism-focused breakdown like this one, is a distinction the mainstream coverage often blurred. Holding assets through an anonymous offshore structure is not by itself illegal. The legal violation, when one existed, was typically failure to report foreign holdings and income to domestic tax authorities, or using the anonymity to actively launder proceeds of crime, evade sanctions, or conceal assets from a legal judgment. A great many individuals named in both leaks had done nothing unlawful at all. They had simply used the same privacy architecture available to anyone willing to pay for it, for entirely legitimate reasons. Protecting family safety, maintaining negotiating leverage in business deals, or simple preference for financial privacy in countries where that's a completely legal choice. The uncomfortable truth these leaks exposed wasn't that shell structures exist. It was that the line between legitimate privacy and criminal concealment runs directly through the same legal instrument, and the only thing separating the two is what the beneficial owner actually does with it, and whether they report it correctly to the tax authorities they're subject to. The tool is neutral. The application isn't. This is also, not coincidentally, why the regulatory response to these leaks took the shape it did. An attempt to make beneficial ownership traceable to authorities without abolishing the privacy tools themselves. We'll get to exactly where that stands in a moment, because as of this year, it's genuinely in flux. If you appreciate that we just spent an entire section drawing the actual legal line instead of just yelling loophole at you, that's the whole reason this channel exists, instead of just doing aesthetic old money content. Comment below which structure surprised you the most, and subscribe if you want every future breakdown held to this same standard. The real estate play: how shelf companies buy buildings without names. Attached nowhere does this architecture show up more visibly, ironically, given the whole point is invisibility, than in luxury real estate. When a $50 million penthouse trades hands in Manhattan, London, or Miami, the buyer very often isn't a person at all on any public deed. It's an LLC with a name like Riverside Holdings 214 LLC, formed weeks or months earlier, registered to an attorney's office address, with no public record of who's actually behind it. There are 4 converging reasons families do this specifically with real estate. Negotiating leverage. If a seller or a rival bidder knows a famous family is interested in a property, the price moves. Anonymity keeps the negotiation about the asset, not the buyer's net worth. Physical security. Public property records are searchable by anyone. A family that values physical safety, particularly families with a public profile or with security concerns tied to their business, has a direct incentive to keep their home address from being one Google search away from anyone with bad intentions. Estate and succession planning. Property held inside an LLC, which is in turn held inside a trust, can pass to heirs without going through public probate court, a process that would otherwise expose the value of the estate, the identity of heirs, and the terms of inheritance to public record. Portfolio compartmentalization. Sophisticated real estate holders often use a separate LLC for every single property, specifically so that a liability event at one property, a lawsuit from a slip and fall, a construction defect claim, can't reach into the equity of any other property in the portfolio. This is straightforward asset protection law, taught in every real estate law course, entirely separate from any privacy motive. The U.S. Treasury's Financial Crimes Enforcement Network, FinCEN, has tried to address the real estate blind spot specifically for years through what are called geographic targeting orders, requiring title insurance companies in certain high-value markets to identify the natural person behind an all-cash LLC purchase, above a reporting threshold. These orders have been renewed repeatedly since 2016, specifically because regulators view all-cash anonymous real estate purchases as a persistent avenue for money laundering. But they only apply in specific target markets, only to cash transactions above a set dollar threshold, and the information collected goes to law enforcement, not the public. The public deed still shows the LLC's name. The privacy from public view remains intact, even where the privacy from regulators does not. The jurisdictions that compete for secrecy. It's worth understanding why specific places, Delaware, Nevada, Wyoming, South Dakota, Nevis, the Cayman Islands, keep recurring in this world, because it isn't random. These jurisdictions are running an actual competitive business model, and it's one of the more fascinating unspoken markets in global finance. The jurisdiction as product model. Delaware built its reputation over more than a century as the default home of American corporate law. Roughly 2/3 of Fortune 500 companies are incorporated there, not primarily for secrecy, but for its specialized court of chancery and predictable, business-friendly case law. Its privacy protections came later, layered onto an already dominant corporate law infrastructure. Nevada positioned itself, starting in the 1990s, as the anti-Delaware. No state corporate income tax, no franchise tax on many entity types, no information sharing agreement with the IRS, and statutory charging order protection that makes it difficult for a creditor with a judgment against an individual member to reach the LLC's underlying assets directly. Nevada does require an initial and annual list of managers or members to be filed with the state, but critically, that filing is not part of the public-facing search database the way it is in some states, which is why serious privacy seekers in Nevada still layer a nominee manager on top. Wyoming, by contrast, collects no ownership information at the state level at all for its LLCs, making it, alongside New Mexico, one of the closest things to a true anonymity jurisdiction in the country, and considerably cheaper to maintain than Nevada. South Dakota has become the domestic trust jurisdiction of choice for many family offices, thanks to some of the country's most favorable trust laws. Perpetual dynasty trusts that can theoretically run for centuries without triggering the rule against perpetuities that limits trust duration in most other states, combined with strong asset protection statutes and no state income tax on trust income. Offshore, Nevis built an entire legal industry around LLC and trust statutes specifically engineered to be hostile to foreign judgment creditors. For instance, requiring a creditor to post a substantial bond and litigate the underlying claim from scratch inside Nevis courts before even attempting to enforce a foreign judgment there, a barrier high enough that most creditors abandon pursuit long before reaching it. The Cayman Islands and the British Virgin Islands, meanwhile, built their reputations as the preferred offshore homes for investment funds and holding companies respectively, offering zero corporate and capital gains taxation combined with common law legal systems, familiar to international lawyers, and a well-developed professional services industry to administer thousands of entities efficiently. None of these jurisdictions are hiding what they offer. Every one of them publishes this information in plain marketing language on formation agent websites, because the entire industry runs on legal, disclosed competition for incorporation fees. The states and territories that offer the most privacy and asset protection simply win more of that business, the same way any jurisdiction competes for any other kind of commerce. The walls are being tested, where the law stands right now. Here's where this story stops being historical and becomes genuinely current, because the regulatory environment around this entire architecture has been unusually unstable over the past 2 years, and it is still not fully settled as of the time we're recording this. In 2021, Congress passed the Corporate Transparency Act, the most significant attempt in decades to pull back the anonymity layer at the federal level. The law's core requirement, most U.S. companies would have to report their true beneficial owners, the real humans behind the entity, directly to FinCEN in a database not open to the public, but accessible to law enforcement, and, under certain conditions, financial institutions conducting due diligence. What followed was one of the messier regulatory sagas in recent corporate law. The rule took effect January 1st, 2024. Litigation challenging its constitutionality worked through federal courts, producing a period of on-again, off-again injunctions through late 2024 and early 2025. Then, in March 2025, FinCEN issued an interim final rule that dramatically narrowed the scope of the law, removing the reporting requirement almost entirely for domestic U.S. companies and U.S. persons, and leaving it in place mainly for foreign entities registered to do business in the United States. That interim rule is explicitly framed as a pause, not a repeal. The underlying statute remains on the books. Appellate courts have upheld its constitutionality, and a further final rule from FinCEN is expected at some point, meaning the domestic exemption could theoretically be narrowed again with relatively little notice. Into that federal vacuum, individual states have started moving on their own. New York passed its own LLC Transparency Act, which took effect January 1st, 2026, though after a gubernatorial veto of the broader original version, its scope was narrowed specifically to foreign LLCs, authorized to do business in New York, rather than covering New York-formed LLCs generally as first proposed. It's the first state-level beneficial ownership law of its kind in the country, and other states are watching closely to see whether it becomes a template. What does all of this mean practically for the architecture we've spent this whole video describing? It means the state-level privacy shield, the anonymous LLC filing itself, remains largely intact for domestic entities right now. What's changed, and changed repeatedly, is the federal and state reporting layer sitting on top of it. The question of whether that same ownership information also has to be quietly disclosed to a government database, even while staying off the public record. That distinction, public secrecy versus confidential government disclosure, is the entire ballgame, and its one most casual coverage of this topic completely collapses into a single, loophole-closed headline that isn't accurate. Regulatory status like this changes fast, sometimes within months, which is exactly the kind of update this channel exists to track for you before it hits the mainstream news cycle. Subscribe and turn on notifications if you want to be first to know when the next rule shifts the entire architecture again. The myth, the line, and the close. Let's end where every video on this channel ends, separating the documented mechanism from the sensationalized. Myth. The myth, shelf companies and layered anonymous structures are inherently criminal, a secret tool used exclusively by tax cheats and money launderers, hidden from ordinary people by design. The mechanism accurately stated, these are legal instruments built on public statutes, sold openly by licensed formation agents, used overwhelmingly for lawful purposes: privacy, security, orderly succession planning, and legitimate asset protection from frivolous litigation. They are also undeniably capable of being misused, which is precisely why regulators have spent the last 5 years trying to build a confidential disclosure layer on top of them, without dismantling the privacy protections that make them useful for everyone else. The families who use this architecture well aren't breaking rules. They're using the same rules available to anyone, applied with more expertise, more capital, and more patience than most people have access to. A Wyoming LLC costs under $100 a year to maintain. A nominee manager service costs a few hundred more. What separates a family office's version of this from what's available to any small business owner isn't secrecy. It's the layering, the jurisdiction selection, and the trust structure sitting on top, assembled by advisors who've spent entire careers learning exactly where each legal seam sits. That's the pattern across everything we cover on this channel. The architecture of generational wealth isn't hidden behind some velvet rope. It's built out of statutes anyone can read, assembled by professionals most people never think to hire, maintained with a level of patience most people never think to apply. This isn't hidden, it's just never taught.